Good evening, everybody. It's Nayef Mubarak with Mubarak Law for this week's Facebook Live. We are going to go over a few important updates and several immigration questions that we've received. So once everybody joins us, we will just get started and hope you find tonight's session informative. And first and foremost, hope everybody was able to have a long weekend. I know that in our office, we were closed on Monday, and we are all still feeling nice and relaxed. You have me here in my Palestinian t-shirt tonight for you guys. So let's see what else we have for you. So last week, some of our good news was, of course, Judge Roberto Moreno was on our Facebook Live. I hope you guys were able to enjoy that conversation. And also, we celebrated my sister Liana's 40th birthday. My family and I, we had an 80s themed birthday, and I know that she really enjoyed it. Some other important updates for you before we get into the immigration updates is it's still time to register to vote in the state of Florida. Doesn't matter who you're supporting. As long as you're an American citizen, please register to vote so you can participate in this year's very important election. You can register to vote. I can probably post that link. So if you are a citizen, you can go ahead and do that. Next week's Facebook Live will be with Besma Allawi. As you know, she is one of the directors for the Florida Immigrant Coalition. Every third Thursday on Mubarak's Law's Facebook page, we do a Facebook Live in Arabic to answer questions ranging from personal injury to immigration in Arabic. So كل ثالث خميس بنعملكم فيسبوك لايف بالعربي مع السيدة بسمة علاوي. So إذا عندكم أي سؤال ابعتوا لنا رسالة وإن شاء الله الأسبوع الجاي بنجاوبكم. Also, October 2nd, this is a few weeks away. Very important reminder, as the immigration fees are going to increase. So if you are eligible to become a citizen, please seriously consider completing your N400 application so that way you can save yourself over $500. Right now, the fees are roughly $725. And if you register before October 2nd, you can save over $500 as the fee is going to about $1,100. That's a huge increase. So if you are eligible, please visit uscis.gov and get started on your N400 application. All right. Processing delays. So I'm sure, as you know, we get so many emails, and for any of the other attorneys who watch, I know you guys can agree that many of your clients' biggest complaint is how long everything is taken. In the last few years, citizenship applications have gone from 6 months to over a year. The same for the marriage applications based, green card applications based on marriage for adjustment of status. They're now showing processing times of over 18 months. This was even prior to COVID. So now with the COVID-19 closures and USCIS just reopening in middle of June, you can probably expect these cases to be further delayed. Now, very often we receive questions from people. Can I speed up my case? Is there anything I can do to expedite my process? You know, I've seen a couple people post on social media said how to speed up your case on USCIS. And, you know, I don't want to mislead anybody. Yes, you can contact USCIS to ask them to expedite a case only if, and they will consider some type of extreme hardship. Now, we've had people with medical conditions on bed rest, and USCIS still said that this was not sufficient to speed up the case. So please, you know, contact a credible attorney before paying anybody who says that they can speed it up for you, because a lot of times, if it's too good to be true, it probably is. Now, for those who have had citizenship applications pending for over a year or 2 years, or in some very long cases, 3 years, even green card applications, and the constant inquiry says, your case is on background check. We're awaiting a background check. How can we make a decision until we have the background check? So what are your options when your case is delayed over a year or so and you want to know what can you do? So in our office, we have just filed a writ of mandamus. This is a federal lawsuit for an individual in Tampa whose green card application has been pending for over a year and a half since the interview. And there's really no reason to delay this case. So we do what's called the writ of mandamus. And this is actually a lawsuit filed against the Department of Homeland Security, USCIS, what I like to call we're suing the government for basically not doing their job. Oftentimes, our clients are very hesitant in doing so, like, oh, is it going to backfire? Are you sure this is a good idea? But most of the time, I actually can't think of one where it hasn't worked, that the federal lawsuits have resulted in a great outcome for our clients. So what I always tell people is, we can't guarantee that the case is going to be approved, but we can guarantee that, or typically that they will make a decision as to why the case is delayed. So and a lot of times with Arab and Muslim names, they're caught up in what's called the FBI background check, and people are waiting years, and that's not really fair to our clients who are waiting. So we file these federal lawsuits to force the agency to make a decision on their case. So how do we prepare a case, or how do we determine a case is ready for a federal lawsuit? Well, first and foremost, we want to check what the processing times were, right? We want to make sure that we are not trying to jump the line by simply filing a lawsuit. So when the case is outside of the average processing time, we then have to make the inquiries. I want to create a foundation and document the fact that USCIS is not doing what they're supposed to do. So we want to give them an opportunity to correct this. So oftentimes we try to have 2 or 3 USCIS inquiries where we get a response, and this can take several months, as USCIS takes 60 days typically to respond to an online inquiry. We also want to make congressional inquiries where you reach out to your representative in Congress and ask them to look into the status of your case. And 9 times out of 10, they end up giving you the same response that USCIS did. We're waiting a background check, where you're next in line. And there's also something called an ombudsman. This is what you can do to have somebody look into your case and the reason for the delay. So once we've laid all this down, this is like a very good paper trail to show that we are doing everything we possibly can, and we have exhausted the remedies available to us, and USCIS simply will not do their job. So we need to go to the courts to have them say, hey, we've contacted everybody. We've contacted online inquiry. We've contacted our congressional representatives. We still can't get a result. This is not fair. This is outside of normal processing time. This is unreasonable. So we file what's called a writ of mandamus. As I mentioned, something that we like to call suing the U.S. government. And we've even done this where cases have been stuck in the embassies abroad, like in Morocco. This is also, all times cases get stuck in administrative processing, and people's files are stuck in this status for years. So you want to be sure you look into it, see if this is a good option for you. It typically can be costly. I know it's not fair, but when you're doing a lawsuit in a high court that requires like this, of course it's going to cost a little bit of money, and not all attorneys are admitted to file lawsuits in your district courts. So and this is something you also want to have a conversation with your attorney to see if they're able to file what's called a writ of mandamus. So as I mentioned, we even did that last week for a client who's been waiting for over a year in Tampa, and we have filed the suit. So we are hopeful that we will get something, a positive result soon. Typically, the government has 60 days to respond to our complaint. This is the name of the document we filed to initiate the lawsuit. So once the government typically responds, we usually see somebody from USCIS or an assistant U.S. attorney reach out to us, say, hey, can you give us some time? We're going to look into this and see what it is, and we hope to have it resolved soon. So please reach out to us if you have any questions regarding filing a writ of mandamus. This can be done for cases delayed here or even abroad in some situations. And then we can move forward with that. I see that we have a comment from Attorney Siraj. He's a super bright attorney in Central Florida, and I know that he practices with immigration and also wills, trusts, and estates and probate. So if you ever need anything, reach out to him. And Siraj, if you have questions about mandamus, we're happy to help. So I look forward to speaking to you about that. All right, next on our agenda tonight is we're getting a lot of comments in Arabic and the IOM and for refugees who are stuck abroad. I hope to answer all of your questions next week, so we will go ahead and address those later, as we just want to get through tonight's questions and updates as it relates to those individuals who are here in the U.S. So on September 14th, the Orlando Immigration Court is finally going to reopen, and it will start to have hearings for non-detained cases. So these courts have been closed since middle of March of this year. However, they are opening the court in phases. So this is going to be phase one, and phase one means that they're going to have individual hearings and no master calendar hearings. If you're in removal proceedings, or what many of you refer to as deportation proceedings, it tells you you have court and they'll circle master calendar hearing, or they'll circle individual calendar hearing on your notice. A master calendar hearing is typically what we refer to as like an arraignment, where the judge looks at your charges and wants to know what's the plan. So they want to know, how did you end up in removal proceedings? And typically your attorney will say, admit or deny, and this is our plan of action, judge. For many of you, if you don't have an attorney and it is your first time attending a master hearing, you can ask for more prep time and perhaps to find a lawyer. If you do this more than one time, the judge can become frustrated with you and can order you removed, because if you don't present a form of relief or defense at your master calendar hearing, it can be up to the judge to go ahead and issue an order of removal. So please, anybody who has a master hearing, you need to attend. If you don't attend your master hearing, you are going to be removed in absentia, and you should probably just lawyer up and get your lawyer to enough time to start to prepare for your case. So at your master calendar hearing, your attorney will represent you. You would be a respondent, and then there's going to be charges like you are a citizen of Jordan. You entered the United States in 2015 on a B1, B2 visa. You have overstayed your visa. You are removable as a visa overstay. So, basically, these are your charges. And a lot of times, these are true factual charges. So your attorney would admit it and say, yes, judge, we admit these charges. And then the judge say, okay, well, what is your form of relief? So we'll say, judge, well, he's married to an American citizen now. We already have an adjustment of status pending. We need to set this for an individual hearing so we can get adjustment. So what is an individual calendar hearing? We call it a merits hearing. So if at your master hearing, you say you're going to proceed with asylum or adjustment of status or cancellation of removal for legal permanent residence, the judge will set it for what's a final hearing called individual calendar hearing, similar to what you see on TV as like a trial. At the individual hearing, they will take testimony, evidence, and legal arguments. The DHS has an attorney, Office of Chief Counsel. You should have an attorney, and then the judge will also ask you questions to determine whether or not you're eligible for relief. So with the courts reopening in phase one in Orlando, they're going to only be having individual calendar hearings. So if you have an individual calendar hearing scheduled for after September 14th, you need to be prepared that your case is going to proceed with its final merits hearing, where the judge will issue a final decision on your case in most circumstances. All right. So we did have some questions about removal and deportation, and I'm going to go ahead and address them now. So what is withholding of removal? So withholding of removal is an application or a form of relief under which originated from the whole refugee laws and the United Nations agreements that if you don't qualify for asylum for a specific section 207, then you may be qualified for withholding of removal. And basically to determine whether or not, and I'll read this, the removal of the alien or foreign national to the country where the alien's life or freedom would be threatened should be withheld. So basically, you didn't qualify for asylum, but we believe that your life would be threatened or you're in danger, so we are going to give you withholding of removal. So what is withholding of removal? So although you are able to renew your work permit, you are able to remain in the United States, you technically on paper have an order of removal. So just like an order of deportation, but they're withholding removal, meaning they're not going to effectuate the order and have you removed due to the circumstances in your home country and that you would face if you were removed. So that is what withholding of removal is. So if somebody has withholding of removal and then later marries an American citizen or their child becomes 21 and is an American citizen, you will not be able to adjust your status without first reopening proceedings to get rid of this removal order. All right. The next question we have, is voluntary departure considered a removal order? No, it's not considered a removal order. However, you need to be careful that even if you take voluntary departure from removal proceedings or from deportation proceedings, then you may have consequences even for not coming back to the United States. So when you have an order of removal from the US, you are penalized. You're not able to return for 10 years. In many cases, even after the 10 years, it's difficult to obtain the visa. However, with voluntary departure, you do not have this penalty of 10 years. However, if you are in visa proceedings because you have overstayed your visa, then you may be subject to a different bar of inadmissibility. So inadmissibility is basically a test or a way to determine whether or not a foreign national is allowed to enter the United States. And if you're not allowed to enter under 212 of the INA, it's because you are inadmissible. Inadmissible, you could be inadmissible for previous immigration orders, for overstaying your visa. For example, if you've overstayed your visa for less than a year, but more than 6 months, you are prevented from returning to the US for a period of 3 years. If you overstay for more than 1 year, you are not allowed to return for 10 years. So if you've overstayed for 2 years, then you take a voluntary departure order. Yes, you're not subject to the 10-year penalty for an order of removal, but you are subject to a 10-year penalty because you've overstayed and you've been in unlawful status for more than 1 year in the United States. So you see a lot of attorneys or individuals seek voluntary departure as a better than having an order of removal. This might not be the case if you have certain criminal grounds or if you've been in an overstay or have unlawful presence. So please double check what your other penalties may be when you take a voluntary departure order. Oftentimes, the judge will read these warnings to you, telling you, even if you take a voluntary departure order, you may be found inadmissible for other reasons. So this is a really important thing that you should know if you are in removal proceedings, to consider whether or not to take a voluntary departure order or to try your case, and just if you lose, you get the order of removal, but it's still the same penalties you would have faced anyways if you took voluntary departure. This question says, can you come back to the US after being deported or removed? So yes is the legal answer. After you've served your 10-year punishment, but you still have to get another visa to allow you to return to the US. Now, within that 10-year period, if you are married to an American citizen, there are waivers that you can apply for, but they are extremely difficult to get. And as I mentioned earlier, even if you wait the 10 years, you can still be denied due to your past history, as I mentioned, for like your visa overstay, your immigrant intent when you are trying to apply for, let's say, a tourist visa. So these will stay with you in your immigration file, like, forever. So you need to be very forthcoming. You need to explain what happened and why the situation has changed. If you were in fact ordered removed and you are now seeking a tourist visa, for example, after 10 years. This question is similar. It says, can I be deported or removed if I'm married to a US citizen? That simple answer is yes. Even if you have children, you can still be removed or deported. This happens all the time, unfortunately, when people don't have other forms of relief or don't qualify for something like cancellation of removal for non-permanent residents, where the requirements that you've been here in the US for 10 years, you're a person of good moral character, and your family would suffer what's called exceptionally, extremely unusual hardship. Do deportation orders expire? Yes. So they do. Once you leave the US after you've had an order of removal, the 10-year clock starts ticking. And that after that 10 years, you can try to seek a visa to at the consulate to eventually get entry back here. However, as I mentioned before, if you were removed because of criminal history, you may not be able to come back because of a drug conviction, for example, even if it's been 20 years. So you need to be careful with that, and you want to really work with your immigration attorney. And if you are in a criminal proceeding, your criminal defense attorney, to make sure that whatever conviction or plea you end up in, what are those consequences going to be like for your future? So who qualifies for cancellation of removal? We mention cancellation of removal very often. There's two types of cancellation of removal. I mean, main types. One is for legal permanent residents, and the other is for non-permanent residents. So for non-permanent residents, you must have a qualifying relative, and that must be a child who's under 21, a parent, or a spouse who's a legal resident or a citizen. And you must demonstrate that these individuals would face exceptionally, extremely unusual hardship. This is the highest hardship standard in the immigration law, and there's plenty of case law out there that says merely being separated from your family is not enough. Finance is not enough. Children being taken out of their high schools to go live with their parents in the foreign country is not enough. These are we really work very hard to demonstrate this hardship, especially when the case law has made the standard so high. So even if you have children or you have a spouse, yes, you can still be removed or deported, to go back to that question. And if you don't have the 10 years, then you're not eligible for this form of relief. So we typically tell people they need to document their time that they've spent in the US, and you need to make sure you're paying your taxes, you're a person of good moral character, you're avoiding criminal activity, because this is a huge discretionary form of relief. And if you have any negative factors, it will definitely come into play when the immigration judge is making their decision. So that pretty much wraps up some of the questions I hope to answer on today's Facebook Live. With the immigration courts opening up, I want to focus on some of these removal questions. For you all, you know it as deportation. The correct terminology is now removal. But if you have any questions, please send them to me in advance, and I hope to get them to you. We did have a young lady send a question early. It says, I have submitted my N400 application more than 5 weeks ago, and this is my second time applying. Will there be a fingerprint appointment again? So with COVID-19, USCIS was issuing notices that state, we will recapture your fingerprint notices. So if you receive that notice, then no, you will not have a fingerprint notice. If you haven't received it, then you just need to wait until you receive your fingerprint application. Right now, it is taking 4 to 6 weeks for you to receive your receipts. So you can then also expect your biometrics appointments to come later on after that. Your attorneys are, we're not in control of when USCIS issues the receipts. Oftentimes, we are just as frustrated as you because all we want to do is deliver the results and give you some peace of mind that your case is pending. But keep following up on that. If you haven't received a receipt notice within 6 weeks of USCIS accepting your money or your package, you definitely want to call the 1-800 number, customer service for USCIS. I am going to ask you guys before I sign off, I don't think I did it earlier, please subscribe to our YouTube channel, our newsletter, and all of our social media accounts. And I thank you guys for joining us. If you have any friends or family who you believe would find this presentation helpful or informative, please share it with them and share it with your friends and family. I hope everybody has a great rest of the week. We'll see you here next week with Basma Allawi, where we will do our Facebook Live in Arabic. Hope everybody has a great night, and thank you for joining me.